Hey guys, this is Sean Hayes with Hayes Attorney P LLC. We concentrate in three areas of the practice of law, that being family law, wills and estates, estate administration and planning, and then business law. In this video, we're going to cover how child custody in North Carolina can be decided. So in North Carolina, child custody, issues concerning custody of your minor child or children, can be resolved in different ways. One way is by agreement. So if the parties have an agreement or believe they have an agreement about how they want to exchange their child and how they want to decide about custody, they can do a custody agreement, which we would advise parties to get any agreement that you have in writing and memorialize. That way, nobody can come back later or get upset and change their mind down the road. A custody agreement is an agreement that is entered outside of court. It is not a court order. It is enforceable, but enforceable in different ways than a court order can be. And a court order, or what we call as a consent order, if the parties agree, can also be entered, which is an order that is signed by the judge and entered by the court. So it can be a court order. And of course, if you do not have a resolution and you end up having to go to court, ultimately a court can decide, and there would be a court order which would be entered after a hearing or multiple hearings concerning custody of your minor child or children. And then that effectively could be the court order, which would be a child custody order. And that's how custody can be decided. Let's go forward and look at the legal standard on the court making a decision about child custody. So in the event that you have to go to court about custody and you go forward with a judge deciding who gets custody and under what terms or conditions, then the legal standard that the court, or the actual law that the court will be applying, is called the best interest standard, meaning that in making decisions about custody, the judge or the court is going to be making a decision that the court believes, based on the evidence presented, that would be in the best interest of the minor child. In other words, the court's not going to be as concerned with, well, is this going to work necessarily for mom, or is this going to work for dad, or is this going to inconvenience them? They're going to be looking at the best interest of the minor child and trying to make a decision based on that. Now, that decision is based upon evidence which is presented to the court that the court can consider. And the evidence, in order for it to be admissible, in order for it to come in, has to meet one of the many rules and be admitted into evidence so the court can actually hear it. And it also has to be on proper procedure. And caveat here, the legal standard we're talking about is a typical custody case where you have, one parent and another parent disagreeing about custody. This video does not cover issues concerning grandparents, does not issue or consider issues regarding third parties, which can also be individuals who can pursue custody, but the standard is different. This is about parent versus parent. So in the event that you do go to court about custody concerning your child or children, the case itself is going to follow a certain process. So initially there'll be papers that'll be filed, starting with the filing of what's called a complaint, and there'll be a claim raised for seeking custody or of your minor child or children. The issue has to be before the court, and this is how you get the issue before the court before you go to court concerning custody. There's an opportunity on many occasions to have a temporary custody hearing. That's where the court can enter temporary orders pending the outcome of the final custody case. Usually the parties will attend custody mediation. If mediation is unsuccessful, then there'll be a more permanent custody hearing which is scheduled, and then there'll be what's called a permanent custody order that is entered by the court. Now, custody in North Carolina is never permanent, meaning that it can also be modified. The standard or legal standard to modify a permanent custody order is different than the prior standard I was discussing earlier concerning the best interest standard. But this is the general process on how a case would proceed through court relating to custody of a minor child or children. So in this case, we have discussed how custody can be decided in North Carolina, the legal standard involved in deciding those cases, and the general process upon which those cases flow through court. If you have any further questions or want to discuss issues of custody with us, we have had extensive experience in this area of practice of law. You can give us a call at 336-633-4529, send us an email at office@hayesattorneync.com, or find out more information on our website at www.hayesattorneync.com. Thank you.